Hi everyone, how are you doing? Hope you're good. Hope you're fine. You're welcome to Lawyers Info Hub. It's a pleasure to have you on this platform. This is a platform wherein we teach law, we share experiences, we invite people sometimes to share their own experiences, aim at helping you become better in whatsoever you're doing. So today we're looking at how to withdraw a suit in court. We're also looking at notice of discontinuance. Now, sometimes in the course of your matter or in the course of practice, you will have some instruction from your clients to withdraw a suit. It can be in the instance that the issues by which or the issues which led to the institution of the matter has been resolved, or for one reason or the other, a claimant wishes to discontinue or withdraw the suit he or she filed. So, in that instance, as a lawyer, you need to do the needful. It's also very important to note that when you have an instruction to withdraw a suit, you need to have it documented. As much as your client can call you on the phone or orally tell you to withdraw a suit, let your client know that you need a further instruction, written instruction. As much as the letter of instructions is institute that suit was, given to you, the notice or the letter for withdrawal or to discontinue the suit should also be given to you. You document it, because some of these clients might come back to know you say, I never said that. It's also very important to know that if it's in a matter on appeal, you want to withdraw. Once you withdraw, it leads to this. As you can't go back to file that appeal again. It's automatic, dismissal. Yes, and if you want to go up, it's not to the Supreme Court. So you must know at what point that your withdrawing will lead to a striking out. Your withdrawing will lead to a dismissal. Now, where parties have joint issues, what I mean joint issues is when parties have filed their processes. Parties have filed their processes. The claimant has filed a statement of claim, and the defendant has filed a statement of defense, and the claimant has also filed a reply. That means parties have joint issues. So when parties have joint issues and you want to withdraw the suit, the defendant may ask for cost because they have spent money in filing their processes. And in most cases, the court will oblige them. Yes, because they will tell the court that, my lord, we have filed our processes and the claimant wants to withdraw. We are not averse to withdrawing the suit, but we'll be asking for costs for coming to court. Sometimes may not be, they've come to court maybe 2 times or 3 times. They would justify why they're asking for cost. So these are things you have to bear in mind when you want to withdraw a suit. But and when parties have joined issues and you want to withdraw, it will lead to a dismissal. It means that you can't come back to file that matter again. But where parties have not filed, issues have not been joined, the court will just strike out the suit. So the stage of the matter determines what the court will do, and it's all provided for in our rules. So when you want to withdraw a matter, you must have these things in mind. What is the stage of the matter? And for the fact that, what if the other party asks for cost? Would be my response? What would be the justification? For example, if a matter has been resolved, parties, rather than withdrawing, parties can now file consent, can now file their terms of settlement, which will now be translated to what? Consent judgment. But where for some other reasons you just want to withdraw, you must know what you're doing. And for a client who has instructed that a matter be withdrawn, let the client, formally, make his instruction known to you so that you hold it. Tomorrow they might come up to say, I didn't know, or I didn't even say it. So you must be very careful when have this instruction. And the fact that there might be others as to cost for a other party who have spent money, who have spent time, who have even gotten a lawyer to represent them, and you're coming to withdraw. Now, how do you now file a notice of discontinuance? A notice of discontinuance is provided, it's in our rules. The form is also in the rules. When you check your rules, at the back of your rule, there are always forms, court forms attached at the back of your rules to guide you in the form of precedent, to guide you to know how to prepare some of these forms or some of these processes. It's just a one-page document titled Notice of the Discontinuance. Yes, at the Court of Appeal, it can be titled Notice of Withdrawal of Appeal. Yes, you know, take notice that the claimant wishes to, discontinue the suit against, sometimes you may not want to discontinue against all the defendants. You may want to just discontinue against one defendant or the two defendants, depending on what the situation is. So whatever the situation is, you let it know. If you're withdrawing against all the defendants, you let it know. If you state it in your notice of withdrawal, if you're withdrawing or notice of discontinuance, if you're withdrawing just against one, you're so stated there. So after you have done stated that, they just a normal dated, now put your address and address for service. You have to serve the other party, you know, of your intention, of your notice. So once the court sees that notice of discontinuance, at least one case is off the court docket. The court will do the needful depending on the stage of the matter. If it's a striking out, if it's a dismissal, whatever it is, you must know the import of what the court's order is. Yes, well, if you struck out, you can come back, but once it's dismissed, you can't come back. And it's very important that you serve. Sometimes you say once you filed your notice of discontent, the court will just strike out the suit. It doesn't work all the time. You must, because especially if it's a matter both parties have joined pleadings, even if you serve the other party, you will still come to court. They let the court know that we have done something and we deserve a cost. But sometimes, if the other party have not filed anything, they might choose not to come to court. And if they don't come to court, the court will just strike out the suit because it's coming from you as the claimant, and the other party has, for them, they have nothing to lose. But if they have put in effort, they will want cost for the labor, the time, the expertise, the cost of getting a lawyer. They want to incur all that. And sometimes you see when these costs are being given or ordered by the court, people take it with with so much triviality. They don't take it so much with heart. So this is an order of court, and the other party can pursue to get their money. So you have to be careful in carrying costs. You have to be very careful in carrying costs. It's also very important to know that the notice of discontinuance you're filing, must be in the right form. As much as people will just tell you file anything, don't just file anything. It has to be in the right form, in the right. It must, contain the right things, the heading of the court, the parties. Yes, then the fact that it's a notice of, discontinuance and who you are discontinuing against. Is it all the defendants? Is it one of the defendants? So it's very easy to withdraw a suit. Look, like I said it earlier, you must be careful in carrying out this instruction. You must be sure is the instruction of your client, and let that instruction be be in a documented form, so you can always rely on it. Peradventure tomorrow someone comes to say, I didn't tell you to withdraw, and the stage of the matter, you have to also explain to the client to say that we might get cost at this point, so that be ready for eventually you get a cost. And if it's an appeal, when you withdraw an appeal, the consequence, you must know the consequence of every action you take. It's easier to withdraw a suit, but very difficult to file. And when you file a suit, the rigors and all of that, but withdrawing it just in a snap of finger, the matter goes off. So you must be sure of what you are doing. It's very easy. You must be sure of what you're doing. And the fact that it is the clear information and instruction of your clients. This is very important. Some people always ask me, how do I withdraw a suit? How do I go about it? It's very easy. Sometimes they say what you don't know is what is bigger than you. For the fact you know something, you have overcome this and you have surmounted it. So go for knowledge. Go for knowledge. Ignorance is very expensive. Yeah, we have so much content on this channel. We've done so many videos on different aspects of law. We've done so many. So I implore you to go through the channel, check those ones that fits your interest, learn them. Knowledge is very important. Refer people, let people know about, share the content. It's been amazing. Yes, I want to thank my subscribers. You people have been so amazing. And for you who is yet to subscribe, please do hit the subscribe button, share the video, and drop your comments, your conversation, your comments. We want to see your comments. If it's a question, we are willing to answer them. If it's feedback, we're ready to give back the feedback, to respond to your feedback. So it's been an amazing time here. I hope you're doing so well. Know that the sky can be your starting point. Do take care.